Well, welcome to the last chapter here in our walk through Court Procedure and Evidence. This is for CJC, Criminal Justice Course 132, I believe, which is Court Procedure and Evidence, and we're doing Chapter 15. The basis of this is the Criminal Procedure textbook by Joel Samara. This is the 10th edition. Published by Cengage Learning, and we are at chapter 15, which is the last of the chapters and one of the briefest, so it doesn't have perhaps as much and being fleshed out constitutionally, and I think that's in part because I don't think it takes a long enough historical perspective, but neither here nor there. We're going to talk about criminal procedure in the time of crisis here for this Wake Tech class. This is being recorded in the the spring of 2023, and this is for the spring semester. So let's jump in and talk about criminal procedure in time of crisis. And by crisis, we're going to look at some issues just briefly. We're going to look at illegal immigration and the Constitution. We're going to look at counterterrorism and war powers. We're going to look at counterterrorism and counterintelligence. That's going to bring in the FISA courts. We're going to look at how the Constitution plays with that. We're going to look at Miranda and terrorist suspects. And we're going to look at whether we try terrorist suspects, these trial in federal courts and the military commissions. And then finally, we'll look a little bit at the impact of the digital age. So jumping in here, we will talk first about illegal immigrants. Now, this is a contentious issue. The flow of immigrants in and out of the United States has varied throughout our American history here. So we've had periods of very heavy immigration. For example, we had a lot of Irish Americans coming in during the Great Potato Famine in Ireland, starting in the 1840s. We had a lot of German Americans come in after the failed German revolutions of the 1848. We had significant numbers of Scandinavians come in. We had large numbers of Italians come in around the turn of the century. We had large Jewish populations come in a little after the turn of the century, a little before. So this is something that is happening quite a bit. We didn't have a lot of law on establishing who could and couldn't come till a little bit later. It used to be very open who could immigrate. But as time has gone on, as the Republic has matured, we've had more and more regulation, more and more law concerning this. So in deportation proceedings, where we're going to stop really someone from coming in and being an immigrant, we're going to look at Fourth Amendment as the predominant issue and whether we can deport them. So the Fourth Amendment, of course, is a stop and search or stop and seizure. And one of the questions here is, when can you stop someone? So suppose you were in a deep inland state. Let's pick one that's, almost completely inside, or is completely inside the United States, like Kansas. Can you stop someone for whatever reason and demand that they prove they are an American? Conversely, does that change if you stop someone in El Paso, Texas, or at the border with Canada? At what point can we stop someone who we suspect to be in the country without permission? We can call them undocumented or illegal, it doesn't really matter. Suspects, when can we stop them? Obviously, we have a governmental interest in limiting immigration and regulating immigration. We also have a Fourth Amendment right to privacy and liberties. Now, usually, if you're just stopping someone to check to see if they are or not here lawful, this is a very brief process. So it has seemed over time to be a pretty minor intrusion in rights. So there are two criteria that most would agree to determine whether the detaining of non-citizens deemed deportation is okay. So assuming we stop someone and we find that they are non-citizens, maybe they claim they're here lawfully, maybe they're claiming asylum, maybe they're claiming that they're married to a resident, whatever. We're going to have some sort of proof that they're here or not here lawfully, and that means something like a trial. So if you let them go, the risk, of course, is they'll flee, that they won't show up for trial. The second issue, of course, is are they dangerous to the larger community? Now, this is where a lot of the agreement stops, however, as to how this is going to be done. First of all, what's the real risk of flight is a fascinating question. What we're going to find is that most people stopped and detained do show up. And the second issue, how dangerous are they? The statistics are really going to show that immigrants commit fewer crimes than native-born Americans. So balancing these two, we're flirting with our subjective opinions versus objective reality. So one of the first cases we can look at is, or we will look at, and this came down in 1976, and this is United States versus Martinez Fuente. And this was a 6-3 case, as I said, 1976. And the question was, we have a stop here of Mr. Martinez Fuentes at a vehicle checkpoint, and they were going to briefly question him. So he was ultimately charged with 2 counts of illegally transporting aliens in violation of federal statute. I think it's 8 USC 1325 or 1324. I forget which one it was. But he moved to say that this is a violation of the Fourth Amendment. You just stopped me because I looked Mexican. That's not good enough. And you can't stop someone just for the way they appear. But the majority opinion, which was written by Justice Powell, and he was joined by the Chief Justice Burger and Stewart and White and Blackmun, Rehnquist and Stevens, said that this is not violation, that this was just a very brief detention, and that the United States has the right to do this. Now, there was a dissent written. The dissent was written by Brennan and Marshall, and they said this is really an intrusion on citizens' rights, because now you can say anybody that looks a particular way is subject to stop, which kind of flies in the face of what we'd early talked about was okay or was not okay. Looking at a later case, we have Denmore versus Kim. Now this case is 2003, and in this case, the history of it, we have Ha-Young Jun Kim, who was a lawful permanent resident, and he was convicted in state court of burglary. And he was held under the INA, which is the Immigration and Naturalization Act, for 6 months, pending a removal proceeding against him. And the question is, does this violate the liberty interest of a lawful permanent resident? And the ruling is no. The detention is a critical element, the risk that they run away, and the danger they pose. So the dissent here, and the majority opinion, again, it's a Rehnquist opinion, and it wasn't solely the conservatives. It was joined by Kennedy, Stevens, Sawyer. I think Ginsburg was in this as well, if I'm not mistaken. I think that's right. Although Ginsburg was part of it, was in part of the concurring and dissenting as well. O'Connor, Scalia, and Thomas were in it too. The dissents, however, which said you can't do this up, is you're locking up a lawful resident without cause. So you're not even showing he's dangerous. He was out on bond, no evidence of flight, and you're saying we can just lock him up? This seems to give the government very broad authority. Speaking of broad authority, let's talk about counterterrorism. Now, fortunately or unfortunately, I guess, the American public has an extremely short memory. So if you went back to the turn of the last century, to 1900, 1901, and you looked at, where the terrorist threats were coming from. By and large, a lot of them were coming from bombings being conducted by left-wing anarchists were blowing up things. So it was kind of a political group. And by the way, there was some ties to foreign nationals here. It often was laid at whether it was true or not, but it was often claimed that a lot of these anarchists were recent immigrants, particularly from Southern Europe. Fast forward, and then you have 9/11, and all of a sudden it takes on less of a ethnic approach or a political approach and more of a ethnic religious approach, where we start to look at people who are Muslims. So when we start to look at what you can do when there is a terrorist event, it is a balancing act between how safe can you be and how much liberty we preserve. Now, during scary things like 9/11, people are much more willing to give up freedoms to protect us. Whether we're really being protected or not is a second question, but the argument is we can keep you safe if you let us do XYZ, read emails or seize documents, whatever we're talking about here. So one of the things we're going to struggle with is, how much are we going to let this go? And there's a good quote in your text, and it says, as I recall, as terrible as 9/11 was, it didn't overturn or repeal the Constitution. And that came down in a case in 2003 because people were still letting the government do all sorts of things, and things the government's still doing. So governmental power during emergency is limited really by two things. What is necessary for them to do? So the government can use extraordinary powers only when it is absolutely necessary to protect people, and it is temporary as soon as the emergency ends. Now, good question here. When do emergencies end? We're at the end of the COVID pandemic, theoretically. The President of the United States said, okay, the epidemic is over. Is it over? People are still dying. When does an event like this end? When does the threat of terrorism end? I mean, you can make the argument that there are still people out there that are motivated by a sort of radical Islamic agenda, which is not the same thing as an Islamic agenda. This is a very, very small group of people, largely unrelated to the religion of Islam, threatening to do terrible things. There's always going to be groups like that. I mean, there's always going to be, if we go back to our anarchists of the 1901, 1902, who set off bombs in Wall Street and assassinated people, the anarchists are still around today. If the government had introduced or started practices to crack down on anarchists, and they did, in 1901, can we say in 2023, 120 years later, that the emergency is not over? So one of the things that can start to change this is legislation. So we do have some recent legislation. Obviously, we've got the Patriot Act, and we've got the Detainee Treatment Act and the Military Commissions Act, because we've got this problem. We have physical possession of some people that we believe are terrorists. Now, if you have physical possession of someone that was fighting you in a war, you can hold them as prisoners of war. The law is fairly well established there. There's even conventions governing it. We have the Geneva Convention classically. There are rules and limits, how you have to treat them, what you do to them. But those are really for state actors. And by that I mean people that are attached to a state like Iraq or Iran or North Korea or Germany or England or Italy, or Japan during the Second World War. These are people that are attached to a state, and there are certain rules that apply. Well, what do you do about individuals that aren't part of a state, but they're part of a larger movement? Now, on one side, we're argued that if you're not careful, you're going to lose your basic liberty and your basic privacy. On the other side, we're warned that if you don't have it, you're going to lose your life, which means you lose your liberty and privacy. So we have a balancing act going on here. On September 14th, shortly after 9/11, we have Presidential Proclamation 7463, which declares a national emergency. And then we have a joint resolution of Congress, the authorization of military force, which said that military force can be used to catch 9/11 attackers and their supporters to prevent future terrorist attack. In November of that year, he provided rules for trials of non-citizens in this war against terrorism. Now, this came down in 2001. President Bush is in office for about 8 years, from about 2000 to 2008. Then Obama takes over from 2008 to 2016. The rules don't change. We keep getting people. People keep being captured or accused and wind up under our control. And most of these people are taken to facilities run by the United States, but outside of the conventional civilian areas of the United States, that is, parts of the state. And the big place they were taken was a military base that we have leased from the old Batista government, the old Cuban government, called Guantanamo. So this isn't new. The Supreme Court said, there are cases where we've detained German nationals. In this case, this was German nationals in China in the 1950s. The case is Johnson versus Eisensteger. And the court said these Germans don't get access to our regular civilian courts. Why? They're enemy aliens. They've never resided in the U.S. They were caught outside of the U.S. They're being held as military prisoners of war. They're being tried and convicted by a military commission that is sitting outside the United States. And these are for laws or wars committed against the United States. And they've never been, at all times, they've been imprisoned in the U.S. Well, apply this to the prisoners that we still have in Guantanamo. Remember, 9/11 is going on 25 years ago shortly. We've had people there for decades. They've never been on U.S. states. They've never been in front of a U.S. court. They're being held in military custody. Now, they're not really classified as prisoners of war. They're not, because there's certain rights as prisoners of war, rights of communication, rights of notification. We really restricted a lot of those. And what we have tried to do is set up military commissions. It's not worked that well. So there's a few problems with applying the Johnson versus Eisensteger cases to the Guantanamo cases. One of the first problems is, what's a non-citizen? Non-citizen is, according to us, anyone who is a past or present member of Al-Qaeda, okay, who acts in some connection with international terrorism, or who harbors them. All right, great. But let's suppose we have someone that is brought into custody in the United States, and he says, I'm not. You've got the wrong guy. My name is Mohammed bin Sadin, and you want Mohammed bin Laden, different guy. And we say, no, we got the right guy. And he says, no, you don't. Well, you need a mechanism, don't you, to determine who's right. Are we right, or is he right? In other words, you need what we've had for a long time, some type of trial. And that is the, fly in the ointment, as they would say. So, detaining terrorist subjects. In ordinary times, even brief detentions are unreasonable unless you have an objective basis, a sort of proof, usually through an appearance, a first appearance, we've talked about those, or something, that, yeah, we've got the right guy. However, when we start to balance our security after 9/11, national security, and the right of individuals, we've held people for 20 years without trial. Okay, so one of the cases in your text that we're going to look at is one of the cases that started to bubble up from, some of these actions after 9/11. So, there's most of these are going to have either Bush's name or Rumsfeld's name in them, because sometimes when you're suing somebody, either civilly or criminally, you sue the official that is the boss of the boss of the boss that's running it. Sometimes you just it's the whole state. So you'll see something like Hodges v. State. Sometimes it's Smith versus, well, today would be Biden, Smith versus Biden. Okay, so the first case to really talk about here is Rasool versus Bush. Came down in 2004. So we had a bunch of people that were captured in Afghanistan, and we had evidence that we thought was sufficient to hold them. They claimed they were innocent. Now, some said, look, they showed up. Did I shoot at Americans? Sure, it was in self-defense. They were shooting at me. They were taken on Guantanamo, and they're held without charge or trial. So it's not like we're going to charge you with terrorism and prove you did it. It's just we're going to hold you as an enemy combatant. And the question was, can we review these? And the reason kind of Rasool got it here was he was a British national. He actually was in Guantanamo in 2002 and had been held for 2 years without access to any court or any counsel, any reports, anything. So we get a habeas corpus petition, produce the body petition, and the ruling was U.S. courts can look at this. One of the reasons they said is they weren't nationals of countries at war with the U.S. They've never had a trial or been charged, and they're being held in a territory over which we have jurisdiction or control. Just because you've got a military base outside the United States doesn't mean that it's special. Now, one of the ways around this, obviously, is don't hold them at U.S. bases. Don't hold them where we have direct control. The dissent said, and there was a dissent in this, was this is really going to hurt military necessity. And it really kind of overturns those earlier cases. Now, the next case, and this is Rumsfeld, and the reason Rumsfeld's getting sued here is he was Secretary of Defense. Here we've got a Yemeni national. So Hamdan was a Yemeni national. He was a bodyguard and a chauffeur of Osama bin Laden. Excuse me. And after that previous case, Congress passed the Detainee Treatment Act of 2005. And it said, okay, one of the things Congress has the authority to do is to establish the jurisdiction of the Supreme Court. And guess what, Supreme Court? You don't have jurisdiction to hear these cases anymore. So this guy was seized in 2001, sent to Guantanamo. After 3 years, he's eventually charged, and he's going to be tried by a military commission. So he sues, and the DTA is reviewed. And they said, well, you can't do this. The Article 1, Section 9 of the U.S. Constitution says you can't suspend the writ of habeas corpus. It says it shall not be, not shall not be, but shall not be suspended unless rebellion or evasion of the public safety requires it. So detainees can go through habeas corpus. You can't keep them forever, and you got to give them access to counsel. Now, the dissent, again, this was led by Scalia, said, nope, we have no jurisdiction. Everything's fine. But again, the courts are struggling to develop this mechanism I talked about to allow some sort of review. The next case, after the Hamdan case, is Boudamini. We have the Military Commissions Act, the MCA, which says, nope, we're going to not allow you to have habeas corpus. And these people were now suing. Some of them have been held for 7 or 8 years without a trial. And one of the questions is, does someone that we're holding as Americans, we're holding them for 7 or 8 years, do they have some sort of constitutional rights? Or is the DTA sufficient? Now, the ruling out of this, and again, this is a contentious issue. And these are, I believe these were Algerians. And 5 of them, they had actually, as I recall, they had fought in the when Yugoslavia broke up, and they had gotten Bosnian citizenship, and one had permanent residency, excuse me. All six were arrested by Bosnian police, and at orders of the United States. The ruling here is that the DTA or MTA is not an adequate substitution for habeas corpus. It doesn't protect fundamental rights. Again, the minority opinion said, nope, it's okay. There was no suspension of the writ, even though you've got someone arguably being held for 7 or 8 years without a trial or charges here. And Kennedy wrote the 5-4 decision here, and he said, this is the Constitution is designed to survive and remain in force in extraordinary times. In fact, you need the Constitution most, not when everything is peaceful and okay, but when things are chaotic and dangerous. Okay. Now, obviously, if we start to talk about the domestic situation here, we've got the counterterrorism, counterintelligence, and the FBI. The FBI is our lead agency. And if we talk about investigating terrorism, and this is going to be something that is designed, terrorism, to coerce the government or to retaliate against the government. And the FBI, even though it cooperates with local law enforcement, is both a law enforcement agency, investigates crimes, but it's also an intelligence agency. It tries to detect foreign nationals engaging in spying. And the primary court that we're concerned with here is a very special court that I think a lot of you probably have never heard of, and it comes out of an act called the FISA Act, which is the Foreign Intelligence Service Act. Now, this was passed all the way back in 1978, when the primary worry was the communists, in particular the Soviet Union. So what it did was it authorized the government, usually the FBI, to keep an eye on anybody engaged in spying on the U.S. Now, it was also enacted after Watergate for different reasons, but it created a special court. And one of the reasons it created a court is that prior to this, Watergate brought out that the FBI and other agencies were really being used to spy on domestic people, and that were exceeding their powers. They supposedly were, going to guard us against the Soviet Union and the bad guys, but in fact they were being used against domestic opponents. So the FISA is passed. So what are the main components? First of all, it applies to any U.S. person, anybody in the U.S., a citizen, a resident, or an alien. And what you need to do when you start to apply it is you show a court that you have reasonable grounds to believe that they're engaged in some sort of Foreign Intelligence Service Act. And if you're going to gather information about U.S. citizens, it should be the minimal amount you need, not a complete fishing expedition, get whatever you want, that isn't related to the terrorism or spying. Now, if you can show some relationship to spying, you're golden. You can get whatever you want. And what you're seeking under FISA is what's called an ex parte order, and this means you apply to a court, in this case a secret court called the FISA court, and you say, we want a warrant to, watch this guy, search this guy's email, search this guy's phone text, intercept this guy's information, place a bug in their house. You want really being able to surveil somebody. So you have to apply to a FISA court, which is called FISC, F-I-S-C. Now, here's the thing. FISC is not subject to the Fourth Amendment requirements. You only have to show it's somewhat reasonable. And the other two big things are it's secret and only the government's there. So you apply to a judge who's a secret judge in a secret court, so there's no public record of it. The only persons in the room are the government, and they present the only information. Now, from that you should gather that it's pretty easy to get one of these warrants to watch people. And between 1979, the year that the FISA court comes into existence, and 2012, we do have the raw numbers. We know that there were about 34,000 applications for warrants or requests to spy on people, and 99.97 were approved. And here's the weird thing about FISA. You can start spying and then apply. You can, unlike ex post facto laws, which are theoretically banned under the Constitution, you can start surveilling somebody because you claim it's an emergency, and then within 24, 48 hours, then you go and get your water. That's pretty broad, and that should show you that really the government has almost unlimited power here. Well, to add to FISA, we've got the Patriot Act. The Patriot Act approves things like roving wiretaps. This is that we're not tapping a particular phone anymore, we're tapping a person. So it grants you very great power. You've also got sneak and peek warrants, where you can break into someone's house without telling them, look around and leave and never let them know. You can enter private places absolutely secretly. It also focuses on lone wolf terrorisms like Moussaoui. Individuals engaged in international terrorism don't have to have specific links to foreign powers, and that's to kind of get over the hurdle of the foreign powers. We also have business records. The Patriot Act business record creates the national security equivalent of a grand jury subpoena for business records to make sure you're not supporting terrorists. So sneak and peek searches allows you can enter private places without the owner or occupant even knowing about it, and that's constitutional. And if the court finds reasonable cause to believe that any notification might have an adverse effect. You can't seize items unless it's reasonably necessary, whatever that means, and you certainly can make copies of everything. It also created national security letters. So the SBI can send a national security letter, which is essentially a request to telephone companies like AT&T or T-Mobile, Horizon, internet service providers, consumer credit reporting agencies, banks, and other institutions saying, give us all the information, metadata, for customer records for intelligence gathering purposes. And this has been expanded as in 2008. Now, it's limited to metadata. You can't target a particular person, but if you look at all the data, you can find people. This was crafted by people that don't understand in many ways how easy it is to identify people from metadata. If you get enough metadata, you usually can find the person you're looking for in that cluster. All right, FBI proactive intelligence gathering. This is driven by a theory of preventive policing. Now, of course, what happens when the FBI, what you want to prevent the crime? As I've said in many classes that I teach, the most efficient and effective law enforcement agency is not the one that catches the bad guy. The one that's the most effective is the one that prevents the crime from happening. Now, when do you start to cross the line? When you are interfering with people that may not be committing a crime of violence, but might be saying some really unpleasant things. So take someone who's saying, I want to overthrow the government of the United States. If you publish a blog that says, I want to overthrow the federal government, I want to overthrow the government of the state of North Carolina. Okay. Is that political speech? If it is, it's got constitutional protection. But what happens when that political speech moves from, I want to overthrow the government by building bombs? Now you're at a different link. Now, one of the things that the FBI is or can do is what's called the Capone approach. Now, this is named after Al Capone, one of the most notorious gangsters in American history. So he was up to a lot of no good. He was killing people. He was bribing people. He was making millions and millions of dollars during the Great Depression, which would be hundreds of millions of dollars today. And they couldn't catch him. So what they did was they didn't go after the direct crimes. They went after indirect crimes. So you don't go after a terrorist because you can't prove he's a terrorist. You go after him because he hasn't paid his taxes. Capone went to jail for income tax fraud. He didn't go to jail for killing people. Now, if the FBI wants to go further, you can gather evidence by catching them committing overt acts or entrapping people. You can conduct sting operations. But then the question becomes, well, how much is too much here? If you have a bunch of people that are saying bad things about America, you send in an FBI agent who says, yeah, America's terrible. And then someone says, well, we should do something about it. And at that point, let's suppose the FBI agent says, hey, I've got bomb making materials. Let's make a bomb and blow up the Brooklyn Bridge. Well, none of them had suggested blowing up the Brooklyn Bridge. But the FBI agent thought that's what they're leading to. And I can get them to commit the overt act of terrorism, and then we can arrest them. And this is the defense of entrapment. You had a bunch of people blowing off steam, and you created it, created the crime. All right, well, let's suppose you actually have someone in custody. Now we're getting to, well, we're going to interrogate them. Now, there was a TV show on, which I'll admit I never watched, with Kiefer Sutherland. And basically, it popularized the idea of the ticking time bomb. You have someone in custody. There is a ticking time bomb in the city. It's going to kill a bunch of people. Can you coerce people to get them to confess? And then when they do confess, what can you use? So the major purpose of detaining someone is to prevent future harm, right? But it's also to, particularly if you're dealing with a terrorist cell, you're going to grab someone, you want to find out who else they are. So you're working, usually when you're breaking up a conspiracy, the way it works is this. You catch a low-level person, level 1, the foot soldier. You get him to give you the next person up the line. If we're using a military analogy, you go from private to sergeant, and then from sergeant to captain. And what you're trying to do is get to the very end. You're trying to get to the guy in charge, if there is a guy in charge. So how much can we coerce people, and what is coercion? So torture, for example, is not allowed. But what's torture? Is keeping someone up torture? Not letting them sleep? Is waterboarding people torture? It's clear that certain things are going to be torture, but the question becomes what's the line there? How far can we go? And again, who's going to review it? So in 2010, the Obama administration said, we want to interrogate suspects for terrorism without giving Miranda. And remember, there are already exceptions to Miranda. You got the emergency exception and a whole bunch. But Obama administration wanted to create a new one. They said, give us the authority to interrogate people without it. And this certainly does go on. If you'll recall the bombings up in Boston, in those cases, those suspects were interrogated for 16 hours before they got the Miranda. The second he got Miranda, he stopped talking. So the people interrogating him were surprised that a magistrate and a representative of the attorney's office came in, and they had planned to keep going. So here's the real question, how long can we interrogate someone who we suspect to be a terrorist? And here's a question for you all to ponder. Let's suppose they confess to something that's not terrorism. Do we use the Capone effect? NSA surveillance. The CIA, which is a different agency than the FBI, theoretically is bound by the same rules. Excuse me, it's important. We had an individual working for the CIA named Edward Snowden. And Mr. Snowden was a contractor. And he found what he thought that the FBI was doing was illegal. And he either, depends how you want to look at it, he either showed the general public to protect our liberties, or he leaked information and risked our security. And he said, look, they're spying on us, and the CIA is, and they're not being regulated. And NSA claimed, well, no, we're only spying on foreigners. But again, that's impossible once you get the metadata. Um, Again, though, the FISA courts have said gathering metadata isn't about a particular U.S. person, so there's no violation of rights. So can I gather all the emails up? Can I gather all the text messages up? Apparently so. Well, what if you've got someone and he's in one of those rare cases you want to try him? Well, you can try them in regular courts, Article 3 courts established by the U.S. Constitution for war crimes under military tribunals. And traditional rules are going to govern here. Um, but only for regular courts. When you have these special rules, you are going to get fewer rights. And there's more relaxed procedures to govern these commissions. So you do have these different commissions that have been established with some caveats. The president can establish military commissions. We have the authorization of military force. We have the laws of war. We have Article 2, Section 2 of the U.S. Constitution. So we can have these commissions. But how do they go forward? How do these military commissions to try suspects act? Well, one of the things is you should have a lawyer to represent you. Also, the Commissions Act permits evidence derived from statements obtained by cruel, inhuman, degrading treatment if, quote, use of such evidence would otherwise be consistent with the interest of justice, which means you can torture people. It also allows people to be tried ex post facto. So let's suppose Osama bin Laden hires me to drive him around, like one of these previous past defendants, and he commits a crime against the United States, and I quit that day. I say, well, I don't want any part of that. I'm done. And I go home. Under these military commissions, you can still charge me after the fact, ex post facto, of supporting him. So any type of material support, you enabled him to become powerful. You enabled him to get places. Therefore, you're guilty of a crime, even though at the time you committed it, it wasn't a crime. This is actually not one of three. We've only got one more left after this. The debate centers around two views. Is it war or is it a crime? Are we going to do this in a military setting? Or are we going to do this in a court setting? People will say, look, prosecutors and the court systems are just not set to protect us. That's the military. So what's the big difference? Let's look at a quick breakdown, then I'll let you go, because I don't want this to run too much over. Is military tribunals are part of war. And one of the things it can do is protect secrets. Like, where'd you get this information? Who'd you wiretap? How were you able to do it? Also, military tribunals almost always convict people. A lot more evidence gets in, including torture. Some countries won't extradite you to the U.S. if you use tribunals. Some countries say, well, yeah, you have these tribunals, but you can't have any of our citizens or any of our suspects because these aren't real courts. Now, there's the converse of this, and your book didn't put it up. Sometimes it's smart to say, find a country that's friendly to you. Poland and Romania we used. That will hold people for the U.S. So the American military goes to the Romanian military, the Polish military, and says, hey, we got this guy we caught in Afghanistan. Why don't you hold him in a Polish prison? Okay, the Poles say, well, hold him. How long do you want to hold him? Just hold him forever. Okay, those guys can sit there for years because, yeah, we caught him, we gave him to the Poles. Now it's the Poles' problem. Civilian courts are part of a civil society, and the way we keep our courts and the whole process honest is it's open to the public, which does mean secrets like, hey, you got this new program that lets you eavesdrop, or you've got this new method of finding information. It should say less likely to convict there, not conflict. And we will keep out evidence that is illegally gathered. So, you have to decide how far you want to go in these courts. There's a lot of issues about these courts, and it's not settled law today. We still don't know what's going to happen in the end. All right, well, that completes the course. We've gotten through all 15 chapters. I hope you've enjoyed it. I hope you've learned something. Um, and if you need to go back and review, of course, everything is open for you. I will be cleaning up these slides a little bit, but I will not be re-recording these lectures. Have a happy and productive day, afternoon, morning, or life, since this will be the last of the lectures you might listen to. Fare thee well.